Hi, I'm Susan Lipp, Editor-in-Chief of Trust and Estates magazine. I'm here today with Jeremy Kisner of SureVest Capital Management in sunny Phoenix, Arizona. So Jeremy, now that the portability between spouses has been made permanent, is there still any need for the long-used AB trust?
Well, Susan, thank you for having me. It's a great question. The AB trust, which many estate planners sold to their clients and put in place for their clients, made a lot of sense from the 90s through really through last year. As we know, the American Taxpayer Relief Act passed at the last day of 2012, and most people know that as the fiscal cliff regulation. One of the provisions of that was that the estate tax exemption was made permanent at the current level, which was $5.12 million at the time, and it's indexed for inflation. So this year it's $5.25 million. But equally important to that is that the portability feature between spouses, which was a relatively recent feature, was made permanent. So what that means is that if I was to pass away, I can not only leave my assets to my spouse, but also when I file my estate tax return, I can leave my exclusion amount to my spouse. Right. So now my spouse, instead of just having the $5.25 million that they would also have my $5.25 million. Now they can leave $10.5 million free from estate tax. That really made the credit shelter trust, typically known as the AB trust, really a lot less applicable. Very few clients actually need the AB trust now. So you've got thousands and thousands of people who have these AB trusts that don't need them, and really what they need to do now is go back to their estate planning attorney and have those trusts revised. One of the reasons that you don't want to stick with that AB trust or the credit shelter trust is because the way that it works just really doesn't make sense anymore. But before, when the first spouse passed away, in my example with my wife and I, if I were to pass away, what would happen is this B trust, the credit shelter trust, would get set up. Half of our assets would go into that trust, and any future growth of that money and the principal would all ultimately go to our beneficiaries free from estate tax. Now, there's some downsides to funding that trust. There's time to set it up. You have to have a trustee. There's some adverse tax consequences for the income created by the assets that are in that trust. The assets in that trust do not get a step up in capital gains basis upon the death of the surviving spouse. And it just adds a whole layer of complexity. Most of our clients, which are your typical retirees, maybe higher net worth than average, but with a couple $1 million, they needed that AB trust, or it made sense when the estate tax exemption was $1 million or $2 million. But now, with $10.5 million between spouses using that portability feature, they just don't need it, and they'd really be well served to go back to their estate planning attorney, have their trust revised, and take that credit shelter provision out of their revocable living trust.
Are there any reasons or any situations where somebody might still want to go with the credit shelter trust?
Yes, there are a few reasons. One reason would be if you have in excess of the $10.5 million, because then you'd want to take at least your exemption amount, put it in the credit shelter trust so that all future growth would be outside of the surviving spouse's estate. That's one reason. A second reason is there is not portability of the generation skipping transfer tax exclusion. So if ultimately this money is going to not go to your children but to your grandchildren, the credit shelter trust could still definitely be applicable.
Okay. Well, thank you, Jeremy. You could learn more about the portability exemption if you go to wealthmanagement.com.
Thank you very much, Susan. It's been a pleasure.